Welcome. Thank you for joining us. My name is Jennifer Airy. I'm the Special Needs Navigator for the Jewish Federation, and this is JAA Your Way, and I'm here with Dana Bookbinder. Dana, you're an elder law attorney. Can you tell me a little bit about that?
That's right, Jen. I've been practicing elder law for over 20 years, and I help families with wills, living wills, powers of attorney, trusts, guardianships, special needs trusts. So I help people plan to protect the future they want.
That's fabulous. Now, when I hear the term elder law attorney, that makes me think of working with senior citizens and, like my grandparents. How does that relate to special needs, and how did you start working with the special needs community?
Great question. When I first started out, I saw that there was a real need for more information and accurate information within the disability community. And so I'm really not just an elder law attorney. I'm an elder and disability law attorney, and I prepare wills and other documents for people of all ages, and I have a particular interest in helping families help their loved ones, because there is so much misinformation out there and it is overwhelming.
Absolutely. Well, that sounds really wonderful, and I can't wait to hear more about what you're going to tell us about today. So, looking into the future, what would you want families that have children with special needs to know about? What should they be planning for?
Well, when a child turns 18, the parents can no longer sign on behalf of the child or legally make medical decisions for him or her. In addition, the child, if the child has special needs, may be able to qualify for Supplemental Security Income, SSI, because the parent's income is no longer deemed to the child. So the important thing is parents should be ready to put a mechanism into place to make financial and legal and medical decisions for the child when he or she turns 18, and parents should also be thinking ahead, how are they going to make sure that their child has enough assets to live on if they should pass away?
Okay, so you said a couple things there I'd love to get some more information on. Mm-hmm. You said that the parent's income no longer counts to the child's assets. What does that mean?
When a child with a developmental disability turns 18, he or she may be able to qualify for SSI, Supplemental Security Income, which is a financial needs-based program that gives the child a monthly payment, but it does have extremely strict rules.
Okay, and so those rules would involve how much assets the child has, how much income they have.
Right.
And so it's like when you're filling out your taxes, you can claim the child as a dependent up until a certain point, and then after that they're their own adult, and that's the same process.
Exactly.
Okay.
And similarly, when the child turns 18, the child is viewed as an adult. The parents no longer have the legal authority to make medical or legal decisions.
Okay. Wow, that sounds really complicated. What sort of documents and things should parents and families be thinking about, getting for their child to protect their future?
If the child is competent to sign a legal document, if the child would understand, not necessarily in so much detail, but have a general idea, an understanding of what he or she would be signing, the child should be signing a general durable power of attorney and a living will or advanced health care directive. So the general durable power of attorney enables the parent or anyone the child would choose to appoint to make legal and financial decisions.
Can you give us some examples of what that might look like? What kind of decisions are we talking about?
Sure. The legal and financial decisions would include signing a lease, for example, for housing, going to the bank, making deposits or withdrawals. Chances are the child doesn't have a retirement account, but if they do, you really need a separate paragraph in that. Applying for public benefits, dealing with government agencies, dealing with the IRS, and doing anything needed to secure good care for the child.
Wow, that sounds like it really applies to a lot of different things.
It does. You want to make it very comprehensive. When I first started out, I remember once in a while seeing powers of attorney that families would bring in from an office supply store or something they did online, and the document would just say, my agent can do anything I can do. But that's not good enough. The banks don't want to hang their hats on that. They want a comprehensive list.
Wow, okay. So if I have a child that is able to get a durable power of attorney, they can understand what that all involves. So would they have to bring you to the bank? Would you have to come with them in order for them to open an account, or if they wanted to, buy a car or do any of these kinds of things, you would have to come with them to be like a co-signer?
Not necessarily. If a child is able to sign a power of attorney, I would meet with the child and ask the child, who do you trust? Who would you want to name to take care of your financial and legal decisions? And you can have co-agents too, by the way.
Oh, okay.
And to make things more convenient, your co-agents could even work independently of each other, which is nice. And then the child, I would draft a power of attorney. The child would sign it in my office in a subsequent meeting. The child would then bring the power of attorney to the bank, and the bank most likely would run it through its legal department.
Right.
And then the agent has the legal authority to act on behalf of the child.
Oh, okay. So they can go in as if it was, for example, my son, and I needed a power of attorney for my son, then I could go into the bank without him with me and say, he needs to withdraw some money for a certain occasion, and they would have no problems with me doing that for him on his behalf.
Correct.
Okay.
That's right, yes.
Oh, fantastic. Now, what about for like health decisions? How does that come into play? Because I know that when you turn 18, a lot of doctors' office won't talk to the parents anymore. They have to talk to the child who's now legally an adult. How does that work? How do you make health decisions?
We would need the child, again, if the child is competent to sign an advance health care directive.
Okay.
And an advance health care directive can be a living will, which specifies in advance whether or not you want life-sustaining treatment, if two doctors were to say there's no hope of recovery. And sometimes a living will actually says, I want to be kept alive no matter what. So people have different opinions on that. There's also a healthcare power of attorney, which many people opt to sign, that says, I'm not going to specify in advance how I want my health care to be managed. Instead, I'm just appointing somebody to talk to the doctors for me. And then there's a health care proxy, which is the type of document that I do generally, that says I'm appointing someone, and I'm big on backup agents. I always recommend have a backup.
Right.
So they appoint an agent and a backup to talk to the doctors for them. And the document also specifies in advance how you want your health care to be managed. Do you want life-sustaining treatment? If two doctors agree that there's no hope of regaining a meaningful quality of life, and the only treatment that's available is experimental and unlikely to work. So you also want to specify, do you want a feeding tube or an IV if you're not getting other forms of life-sustaining treatment. Like the power of attorney, it's very important that the living will be very specific. You want to list types of life-sustaining treatment. And you also want to make sure you get the Healthcare Privacy Act in there. Under the law, you need to reference the Healthcare Privacy Act to enable your agent to access medical records.
This sounds like a really kind of difficult topic to deal with. You're talking about death, you're talking about somebody being in a really horrible health situation where you might need feeding tubes or be on life support. These are really difficult topics for families to deal with. Why should we be talking about them now? What is the benefit for that?
The benefit is you need to plan ahead. Making a decision when you're in a crisis never leads to the best decision. So it's much better to plan ahead. And also, you can't legally sign these documents if you're already unconscious or some event happened where you're not thinking clearly. So it's absolutely necessary to broach these subjects while things are okay.
It's like buying house insurance. You know, when you own a home, you want to have that insurance for just in case, because you never know, something might happen. This is kind of that same situation where you don't know what your future health is going to be, and this helps protect that.
I agree, it is.
Okay, great. Now that we've been talking about things we can do if your child with special needs has, you know, fairly high functioning, they're able to understand what they're signing. But what if your child isn't able to understand what they're signing? What's next?
And that happens a lot. When the child turns 18, if the child cannot sign a power of attorney or living will, then the parents could go to a court and apply to become the child's legal guardian. And this is more time-consuming and normally a more expensive proposition than simply having the child sign a power of attorney. The guardianship is an application to the court that the court takes very seriously. So the court does appoint a second attorney to do an independent evaluation of the child and confirm whether the child can really handle legal and financial and medical decisions. And the court takes this so seriously because a guardianship generally involves taking away an individual's right to vote, to marry, other civil rights. Now, to limit the effects of this, often we can do a limited guardianship because sometimes a child may not be able to manage finances, but the child still should be allowed to get married. So we try to make it as limited as we can, but often it is a plenary guardianship, and this enables the parent to make legal and medical decisions for the rest of the child or the parents' lives anyway.
Okay, great. I like that it's able to be limited, so it's really customizable to the child's situation and what the family hopes for their future, that they want them to be able to do. And like you said, get married, maybe, you know, have a future family, things like that. And this is just to help protect that future.
That's right, and that's also why when you're thinking of a guardianship, you should enlist the help of someone who's done this or who does this regularly. And the law keeps changing too. Now, New Jersey lightened the requirements a little bit for submitting a guardianship application. It used to be that you needed certifications from 2 doctors saying that the child needs help with the legal and financial decisions and that the prognosis is not likely to change. And the requirements are a little bit more flexible. You can enlist social workers or therapists also for these certifications.
You made a statement that the prognosis is not likely to change, that they had to have the 2 doctors sign off on that. And I'm very curious, is there ever a situation where it might change? Maybe somebody got into a really bad accident and the parents applied for guardianship, and then maybe through therapies, through new medical breakthroughs, something, you know, happened and this person was able to regain a lot of skill and ability. Is there a way to reverse the guardianship if necessary?
Absolutely, and you brought up that there are temporary guardianships too. So you can apply to be a temporary guardian, but absolutely, if the child regains legal competency, you can go to court and terminate the guardianship. And then I would recommend have the child immediately sign a power of attorney.
Yeah, that sounds like a great plan.
Yes.
So when we go for a guardianship, you said that it's customizable. Can you give me some examples? Because I'm having a hard time understanding, how can you customize something for healthcare? If you have a guardianship regarding healthcare, at what point is the child able to make decisions, and then at what point, for example, would the guardian need to step in?
Well, I was involved in a guardianship that brings that up, where the child was able to make meal selections for himself and make everyday decisions, but just not the big, complex decisions.
Okay, so if
Yeah.
they needed a procedure done, or they needed to
Right.
go in and to the doctors, and maybe they needed to go see a specialist, things like that, that maybe are a little bit more complicated than just everyday, I have a sore throat, I need to go see the doctor kind of decisions.
Exactly.
Okay.
Yes.
Financially, can you set a dollar limit on it? I know, for example, when you turn 18, from what I remember, I got an awful lot of credit card applications in the mail.
Right.
And you could really get yourself in trouble with those. What would happen if, you didn't realize that, your child signed something, and all of a sudden now they have a $5,000 credit card, and what do you do? How do you work around those sorts of things? Do you have recourse now that you have a guardianship?
Yes, if there's a guardian and your child is signing things for himself or herself, because, as we explained, that the guardianship takes away the child's right to sign on his or her own behalf, those credit card applications would be void.
Okay, so
And I should also mention that there's another court procedure called a conservatorship, where the individual is competent, but there's a concern that the individual may be taken advantage of. And so you could go to court and appoint a conservator who would sign on behalf of this competent individual to guard against the possibility that a financial company or another individual may take advantage of him or her.
okay, so it's a good kind of like a safety net.
Yes.
Okay, great.
Yes.
I like that those are able to be put in place, because it sounds like a great way to protect your child's future.
Yes, if you know what the issues are, you really can plan ahead and make a tremendous difference in guarding against future problems.
Fantastic. Now, when you're looking at the future, we've talked about legal issues and guardianships. Are there other things that families should be thinking about? Because if my child's living with me, and then all of a sudden I'm gone one day, where are they going to live? How are they going to take care of themselves? How are they going to, afford their food, afford rent, and things like that? Are there measures that can be taken to protect them?
Sure. I recommend that the family has a planning meeting with the elder care attorney, elder and disability law attorney, a financial planner, social workers, a life care planner, and have a meeting to talk about what assets are available, what the parents' wishes would be, what the child's wishes and preferences would be, social, entertainment needs, spiritual needs, and set up a plan for the child, a care plan. And also, if a parent winds up setting up a trust for a child, those types of things could be part of the trust too, as well as having them in an additional plan.
Okay, great. Can you tell me a little bit more how a trust works? What can it be used towards?
A trust is essential in many situations because it enables the parent to establish a vehicle to protect assets for the child. Many children who have special needs are on supplemental security income, that's SSI, or Medicaid, or other programs. The SSI and Medicaid programs happen to have very strict financial limits. You can't have more than $2,000 and qualify for SSI or Medicaid. So if a parent wants to leave assets to the child in an inheritance, or maybe another relative wants to gift assets to a child with special needs, a special needs trust is usually the way to do it, because the special needs trust has certain provisions in it which preserve the child's eligibility for benefits.
So this sounds like a really important conversation, not just between the parents, but with the extended family, because if grandma and grandpa want to leave a gift after their passing, maybe, say $20,000, part of a life insurance plan, all of a sudden that could wreak havoc on their government assistance, their Medicaid plans, and all of that. Whereas instead of leaving it to the child, they could leave it to the trust instead, and they would still have access to it. Is that correct?
Yes, and many families make the mistake of either leaving assets directly to a child with special needs or leaving the assets to a sibling. who's going to hold the money for the child with special needs. And both of these turn out not to be good ideas. Leaving the assets to the child with special needs, if that child ever needs to qualify for SSI or Medicaid, this is going to be a problem because the child will be over the $2,000 limit, and leaving assets to a sibling to hold for the child with special needs is also a poor idea because maybe this sibling, he or she has a financial issue and spends the money on himself or herself, or gets divorced or has creditors. So the special needs trust secures the money for the child.
Yeah, or if the sibling themselves needs to qualify for government assistance, because something happens, they need unemployment, they need some sort of government service, and that would count against them as their own benefits, as their own assets, I mean.
I agree. Mm-hmm. And sometimes a parent needs to apply for Medicaid too. So if a parent is trying to apply for Medicaid, there are exceptions in the Medicaid law to the transfer rules, which are generally very strict, but these exceptions allow a parent to transfer assets to a child with special needs, and if that child is on SSI or Medicaid, himself or herself, the parent can fund a certain kind of special needs trust for the child, and that would enable the parent to qualify for Medicaid and also the child to preserve his or her benefits too.
Okay, great. Can you tell me a little bit about what can you use the special needs trust for? What kind of expenses can that be, put towards?
The special needs trust is not a support trust. It is supposed to enhance the child's life. So you're supposed to use it for entertainment, therapies, medical equipment, but not food and shelter.
Okay.
Occasionally, it becomes necessary to use some trust assets for food and shelter, and if you do that, it reduces the income that the child receives every month from the government benefit SSI.
Okay. Now, are there things that you can set up as a parent that would be able to go towards food and shelter? Are there other kinds of accounts or trusts that you can use?
Well, there are other devices. An ABLE account is a new type of account in New Jersey. The other states also, not all of them, but a few states now have ABLE accounts. And this is a relatively new act that enables a parent or a beneficiary to set up an account that would be for the child's benefit. And there is a limit to how much you can fund it each year of $15,000 per year, which is the current annual gift tax exclusion. Sometimes that limit gets bumped up every year, and the ABLE account does have a lifetime maximum of $100,000, but that's another vehicle where parents can, or the special needs beneficiary can protect his or her own assets and use the money while not jeopardizing public benefits.
Okay, so the ABLE account combined with a special needs trust. So you have the special needs trust for entertainment, those extras that are fun and make life a little bit easier, and then your ABLE account is for your everyday like household and things like that. Is that my understanding?
Yes, but really the SSI supplement security income payment is supposed to be for the food and shelter.
Okay.
That's really what that's designed for.
Okay.
And I did want to bring up, there's another vehicle where parents can protect money. If a child has some money and it's not enough that they would want to create a whole trust, then there are things called pooled trusts in New Jersey, where your money can become part of a larger pool, and you normally have a nonprofit as your trustee, and the nonprofit would make distributions to the child, but they're very strict about what they would use the money for, because everyone can share in everyone else's benefit. But the nice thing is you never run out of money because you're part of a pool.
Would that be a program like Plan NJ, for example?
That's exactly what I was thinking of, yes.
Mm-hmm. Okay,
yes.
Great. Now, when you talk about the ABLE account and the trust, what happens after my child was to pass away? Say there's still money left in the trust, there's still money left in the ABLE account. What happens to those funds?
There is a requirement that any money left in the ABLE account, first it has to pay back the state of New Jersey for any Medicaid benefits paid out to the child, and then if there's any money left, it could go to a remainder beneficiary. The special needs trust, this answer depends on whether it's a first-party special needs trust or a third-party special needs trust. So the difference between a first-party special needs trust and a third-party is a first-party special needs trust contains assets of the special needs beneficiary himself or herself. So this may be settlement proceeds from a lawsuit, it may be an inheritance that another relative left him or her but didn't know to put it in a special needs trust. So those are assets that the beneficiary owns himself or herself. A third-party special needs trust contains assets that another individual supplied, and the other individual set up the trust for the beneficiary. So this is commonly used in an estate plan. When parents set up a special needs trust for their beneficiary, this would be a third-party special needs trust. And it's key to understanding the difference, because a first-party special needs trust, you have to pay back the state of New Jersey for any benefits paid on behalf of the Medicaid recipient. In a third-party special needs trust, it doesn't matter if the benefits recipient received Medicaid, there is no payback.
Okay.
Yes.
And then what about the ABLE accounts? Now, I've heard that the money in that goes towards paying back the government. Is that true?
Yes, that is true. So in the ABLE account, like the first-party special needs trust, you have to reimburse the state of New Jersey and any other states that if the child moved during his or her lifetime, you're responsible, as with a first-party special needs trust, to repay the state first, and then if there's money left over, it could go to a beneficiary.
Mm-hmm. Okay. So if I wanted to go forward and get a ABLE account for my child, do I have to get an ABLE account in the state of New Jersey? Does it have to be here, or can I go to a different state, and why would I want to do that?
You don't have to use the ABLE accounts in New Jersey. Different states have different features. Some may let you use a credit card more flexibly than others. So there could be differences. You have to research it.
Okay, great. That's good advice. So I kind of want to review a little bit what we've talked about. We've had a lot of really heavy topics, and I just kind of want to make sure that we get a good understanding of what we're talking about. So when I'm looking into the future, I want to assemble a team. Can you remind me who that team should be?
Yes. You should have an elder and disability law attorney, a special needs education attorney in most cases. You should have a life care planner, social workers, therapists, and a financial advisor.
So to continue our sum up, once you've assembled your team and you've sat down, you created that life plan, that vision for the future, what's next?
You have to make sure that your beneficiary designations line up with your estate plan. And many people make the mistake that they forget to coordinate the beneficiary designations with their estate plan. If you name a son or daughter as your beneficiary on an IRA or an annuity or a life insurance policy, that overrides the will with regard to that specific asset. So if you name a child with special needs as a beneficiary, even if you have set up a special needs trust for that child, that asset would go straight to the child and bypass the trust. So it's very important that the trust be named as beneficiary.
And that's why we want to get our financial planners involved in these discussions as well, so they can check those things for us and get all of that, squared away and taken care of. Okay. Now, once we've established our plan and our vision, we've got our beneficiaries decided, then we're looking at, do we want the special needs trust and what kind? Can you review for us again, what's the difference between the first and the third party? Because that was really confusing, and I'd love to go over that again real quick.
It can be confusing. The first party trust contains the assets that are owned by the beneficiary himself or herself. And these types of trusts are much more restrictive than a third-party trust. A third-party special needs trust contains assets that another individual, it could be a parent or other relative, puts in trust for the individual with special needs. So those assets were never owned directly by the individual with special needs. And the first party trust does contain a requirement to repay the state where the beneficiary received Medicaid, whereas the third party trust does not need to pay back the state for Medicaid benefits received by the beneficiary. The first party trust also must be irrevocable, which means that once it's established, the terms may not be modified. In addition, the first party trust requires the trustee to submit annual accountings to the state, assuming that the beneficiary is on Medicaid or supplemental security income benefits. And believe it or not, the trustee has to submit notice to the state before any distributions are made from the trust in excess of $5,000.
Wow, that's really complicated. Sounds like a hassle, a lot of hoops you have to jump through for the first party trust.
It is, but it is worth it to preserve the beneficiary's eligibility for Medicaid.
Yeah, absolutely. When you're looking into the future and you are making a huge decision on who you want to be to oversee these trusts, to oversee these plans, and to make sure that everything follows the way that you envision when you set out that future plan with your team. How do you pick somebody to bear that responsibility? Is it a family member? Who do you look to for that?
That's a good question that families should think very carefully about. You need a trustee who's knowledgeable of the eligibility rules for Medicaid and SSI and any other programs that the beneficiary may be receiving. If you pick a family member who doesn't understand how strict these rules are and how often they change, then the trustee may run afoul of the rules and unfortunately terminate the beneficiary's eligibility for benefits. I'm very big, as I mentioned earlier, on backup trustees, backup agents. So definitely pick a trustee and a backup. And it is preferred to get a corporate trustee. You had mentioned Plan New Jersey earlier is a wonderful choice for trustee because they understand all of the rules. And when you are a trustee, you shouldn't write a check when you're making distributions directly to the beneficiary. Instead, you should really pay for the service that you're getting for the beneficiary, so the beneficiary doesn't put the money in a bank account and lose benefits.
So, for example, if the beneficiary, my child, went to somebody and said, I have a bill or I need money, or if you're involved and you're managing their finances, you don't want to put the money into my child's account. You want to pay the phone bill directly. You want to pay the whatever the vacation costs were from the trust, and bypass my child's bank accounts or finances, so there's no connecting the two back.
Yes, and it's also key that the beneficiary must have no right to compel distributions from the trust, because if the state were to interpret the trust that the beneficiary had any right whatsoever to control a distribution, it would not qualify as a special needs trust, and that would also terminate the child's eligibility for benefits.
Okay, that's a really good point. We want to really protect those services because as a parent, we fight so hard to get those Medicaid services and those SSI benefits and find those doctors and get that team assembled. And it's really unfortunate that something that's meant to be of help, like for example, grandma and grandpa putting them in the will, could endanger all of those years of hard work and those plans that you've put in place. So having a plan like a special needs trust and a guardianship put in place can really help protect all of that.
Yes, communication among the family members is critical.
Great. Is there anything else that families should be thinking about? We've talked about powers of attorney, we've talked about guardianships and trusts and ABLE accounts. Is there any other piece that you would want families to consider, or any other supports that might be available to them?
Well, there are many social workers in the community who can do plans and monitor the care. I think it's not only important to secure care for your child, but get an independent agency to monitor the care and keep checking up. And as technology changes, you have more options to keep your child safe, and the law keeps changing too. So you have to keep checking in with your elder law attorney and other advisors to make sure that there are no changes.
Right, and that's why it's important to have somebody like yourself who's very aware of these changes and knows the policies, and know trusted people in the community that are available to help as well.
It's important to have a lot of resources in the community.
Okay, fantastic.
Like your organization.
Oh, thank you. Well, thank you so much, Dana. I've really enjoyed our time, and you've made some really wonderful points, and I really hope our families benefit from this conversation. And if they have questions, can they feel free to call you?
Absolutely.
Okay,
Thank you very
fantastic.
much, Jen.
All right,
I
thank
enjoyed
you.
it.
Thanks.